this is why there are people going to people's houses at 3 a.m. and 4 a.m. But is it something so unbelievable? No, this method, how is it that every 5 years, under the chairmanship of this particular officer, we have a crisis? Let me show you another step taken by Mr. Chebukati in this election. On the 8th of August, Mr. Chebukati announced that the gubernatorial elections for the next day in Mombasa and in Kakamega were postponed. And he puts it out in a Gazette notice. Once again, we have queried whether that was a decision of the Commission or of himself. And we asked the reasons. And he has set out the reasons in that same affidavit at page 25. And at page 25, he sets out why he had to do it. Sorry. And this is what he says. Paragraph 103 of that affidavit on page 25, that despite spirited efforts by him and his whole teams, whatever they are, to have the printer replace the ballot papers urgently, it was not possible, he says, to complete all logistics in time for the elections. In the circumstances, the Commission was constrained. Now he is seeking their umbrella, was constrained to postpone the gubernatorial elections in Kakamega and Mombasa, and then he gives the authority. Pursuant to Section 55B of the Elections Act and Regulation 64 of the Elections General Regulations, which allows the Commission to postpone an election in a constituency, county, or ward, quote, I've been quoting, quote, where it is impossible for an election to proceed, full stop. Then he says that the postponement was for a limited. So he has set out that it was postponed under these two sections and regulations where it is impossible for an election to proceed. So we look up section 55B of the Elections Act. Here is 55B of the Elections Act. Postponement of elections by the Commission. Section 1. The Commission may, where a date has been appointed for holding an election, postpone the election in a constituency, county, or ward for such period as it may consider necessary, where A, there is reason to believe that a serious breach of peace is likely to occur if an election is held on that date. But Mr. Chebukati says that's not the reason. B, it is impossible to conduct the elections as a result of a natural disaster or other emergencies. He hasn't said it was because of the natural disaster or other emergencies. He doesn't say they were there. C, that there has been occurrence of an electoral malpractice of such a nature and gravity as to make it impossible for an election to proceed. A, B, C. None of these were applicable, but even if they were invoked, none of them were present in fact. But see what Mr. Chebukati had done. He had lied. He said that in Section 55B, it is provided that they may postpone if it is impossible to conduct the elections, full stop. And when we look at Regulation 67, it's identical with the same conditions. Once again, he is lying. And there is not the slightest concern for the values of Article 10 and the whole Constitution. This is two things here to watch, members of the court. Number one, that this is a person who is saying these things with impunity. This is a person who sets out the wrongdoing that he is practicing with mens rea. This is not a mistake. This is a very calculated, very calculated subversion of forethought. He plans this, does it on the last day, doesn't explain what those conditions are which make it impossible, and delays it. And then it does not matter to him that at least 2-3 million people in Mombasa County and Kakamega County have been deprived of their right to vote. That it is important and reversing that a presidential election has to be held on the days when the general election is held. This is how the mess that has brought 100, a full Supreme Court, here. Because this man, when you ask him these things, justifies it, knows that it is wrong, and puts it in an affidavit. And then says to us, you explain it. So, it is important not that we cannot rely on a single thing. This is a practiced artist of the destruction of our institutions, because that is what happens. He did it in 2017. He was caught. When the court ordered him to disclose more things, he disobeyed the order, never did it, and took the benefit of the continued change of circumstances, a new election, etc. And now, back again, he is here. Same person, same sort of tricks. This was in 2012 and 2013, this amendment. This man has been practicing this for 2 election cycles. And he comes here, read this affidavit. Every 2 sentences he says, I'm conscious of the importance of my work as a state organ or a state officer. I'm a practicing advocate, and my professional integrity would never allow me to do these things. I told the NSIS, I am standing up for what is right. I told the 4 commissioners, never, I don't do things like that. When people are running the person who calls out louder, thief, thief, thief. So that this is what has been going on, and it is destroying our institutions. This case is about the democratic institutions of Kenya. And it is about how we protect those institutions and how we stop people who are attacking those institutions. We cannot do it on the streets. We do it through the institutions. We were doing it through the bar. Now the burden has come to the judiciary because of the new constitution. And we pray that that burden will be borne constantly, persistently, with courage, because when such burdens are not borne, all of us fall down, including courts. And is that something that should be? Is that something that has to be spoken to? I mean, spoken for by a party who is seeking justice? And the answer, fortunately, is no. The Constitution itself gives the answer, and that is set out in Article 3(2), which says that it is the duty, every person has an obligation to respect, uphold, and defend this Constitution. Defend? Armies coming from abroad don't care about our Constitution. We're not defending this Constitution against armed incursion from anywhere. That defense is from enemies within who use this type of thing. It is not unusual. The subsidiary legislation emanates, as we all know, from the institution itself. And a letter goes to the Attorney General saying, I would like to amend this. This is what I want. The Attorney General says, give us a draft. The draft comes, sent to the draftsman, legal draftsman. First draft goes to various ministries, Attorney Generals, other departments, public, to the Interior Ministry, la. So this has been done very calculatedly. Very few of us are going to read this to see it, but no one even saw it in 2017. So we have work ahead of us. And so may I turn then to the second issue that I'm coming on to submit to your ladyships and lordships, and that is thank you. Sorry. So the prayers are there. We are asking for prayers in the petition, and we respectfully request that the court looks at them and deliberates on them. But the court also has powers from other places. For example, in the Elections Act itself, under Section 80, subsection 4, the court has power. The court has power to, if there is evidence that you find, you may issue directions that the certificate is to be made out in the name of the person who has secured more votes. The second prayer we do make outside this is this, that we cannot have, whatever the outcome of this petition, we cannot have the self-discredited person who is giving false affidavits and doing all these things to be the chairperson of the IBC or anything at all. And so we are also saying that there are two prayers in relation to this. The Article 3 of our Constitution says this. Article 3, sub-article 2. And this is at the heart, I pray, of the judgment that this Honorable Court gives. 2. Any attempt to establish a government otherwise than in compliance with this Constitution is unlawful. Any attempt to establish a government otherwise than in compliance with this Constitution is unlawful. And so, in what is a 34C? A 34C is what leads to 34B, which leads to the declaration of a precedent, which is the formation of a new government. That is what was going on the 15th of August there. An attempt, and even here, right now in this court, there are people who have filed things in contravention of the Constitution, saying that what is in contravention of the Constitution is correct. And right here in this, there is an attempt to establish a government otherwise than in compliance with this Constitution. It's unlawful. So, if this Honorable Court finds that Mr. Chebukati is responsible for and has committed actions and decisions which are an attempt to establish a government otherwise than in compliance with this Constitution, we pray that you make a holding that he has done such an attempt, which is a mechanism within the Constitution itself and within this election petition's four corners, and another declaration that this person, pursuant to Article 33, sub-article 2, is no longer fit to hold public office. We go further. Is it possible that we can stop it by stopping Mr. Chebukati alone and we submit? No. It doesn't matter whether Mr. Chebukati will find another Mr. Chebukati next time. We have to stop those people who do not take those steps, but who take the benefit of those steps. And those people who take the benefit of the steps which the Constitution itself says is unlawful cannot take public office on the basis of a false 34C, 34D, of a declaration made by a person who knows he's made it falsely, so that we also pray that those who seek to benefit from the wrongdoing of Mr. Chebukati are themselves caught by Article 3, sub-article 2, and you have the powers to make the same orders that they too are making an attempt to establish a government in Kenya otherwise than in compliance with this constitution. And we pray that this court moves our country forward with those two steps of orders in relation to all parties benefiting and all parties carrying out this mass attack upon Kenyan democracy. Thank you.